I think every practicing attorney in the county needs to attend this session. So thank you all for coming today. So pleased to have our panel with us today. Judge Renee Cohn-Jubileer of our Commonwealth Court, Judge Murphy from Montgomery County, so she had to travel in a little bit, David Price, David's title is Senior Counsel for Information Technology of AOPC, and then Andrea Tuominen, also with AOPC. Andrea is the Assistant Court Administrator at AOPC. So very thankful to all of you today, and it's all yours. And I think all of our technology should function appropriately. Thank you, Judge.
Thank you very much, Liz. We really appreciate the invitation and being able to be here today to discuss the new public access policy for case records for the appellate and trial courts. Can everybody hear me? I'm pretty loud. So the Supreme Court adopted this policy on January 6, 2017, but it's not effective until January 6, 2018, which is fast approaching, but at least it gives us a year for implementation. The statewide policy applies to all case records that are filed in and maintained by the appellate and trial courts. Today, we are going to discuss first, privacy and court records. What courts are currently doing to protect confidential information in court documents. Why now for the adoption of a new policy? And what does the new policy provide and require? So, practical obscurity. I love this term. It's wonderful. The United States Supreme Court used this term to describe the need. They were applying the law enforcement exemption in FOIA to, quote, balance the privacy interest in maintaining, as the government puts it, the practical obscurity of the rap sheets against the public interest in their release. This term beautifully transitions us to the legal framework within which we must understand our obligations. As I am sure you all know, there is a legal basis for accessing court records in the common law and in state and federal constitutions. In the common law, there's a presumption of openness of public judicial documents to inspect and copy the documents. There's a First Amendment and Sixth Amendment, First Amendment right to the press, freedom of speech, Sixth Amendment right to public trial, and in the Pennsylvania Constitution, that all courts shall be open. In Pennsylvania, there is also a legal basis for protecting the right to privacy, which is rooted in the Constitution and recently reaffirmed by our Pennsylvania Supreme Court in a case involving the right to know law and the Pennsylvania State Educational Association. There's always been a tension between these constitutional protections, which was ameliorated somewhat, as the court described, by the practical obscurity of the documents. That is, one had to go to the courthouse in Pike County, or Dauphin County, or Philadelphia County, or Erie County, find the clerk's office, get the file, look through the file, find the information. Also referred to as miles to files. Now, information previously available only locally is available globally with a keystroke. So there is no longer really any privacy in our public records. For example, there are for-profit websites with names like Mugshots or Busted Mugshots or just Mugshots, which post mugshots from arrests long after pretrial diversion or other programs have allowed these individuals to have a clean record. Maybe in the eyes of the law, but not online. One way these sites made money was charging a fee to remove the image, at least from the site that was paid. Mugshots are merely artifacts of an arrest, not proof of a conviction, and many people whose images are now on display were never found guilty or the charges were dropped. In 2013, there were more than 80 mugshot sites, and removal from one site didn't necessarily remove the picture from another. A federal lawsuit over 3 Ohio mugshots resulted in settlement, and they had to remove the offending mugshots and pay $7,500, but it left hundreds of thousands of mugshots in Ohio alone unaffected. There have been efforts at legislation and with payers not to process payments, other efforts to try to rein in intrusions, although there has also been understandable resistance from journalists and others who assert that public records should be public, and any restriction on booking photographs raise First Amendment issues and impinges on editors' rights to determine what is newsworthy. So, could something similar happen with online court records? Let's see. Using Alabama's publicly accessible online court records, which included names, birth dates, and social security numbers, a man opened bank accounts and obtained loans in people's names, faked driver's licenses allowing him to obtain debit cards for the bank accounts he opened, and access money transferred in from payday loans companies on the loans he secured. Even the Alabama governor's social security number is in those records. So what kind of information could be obtained in a Pennsylvania court record? Well, many court filings contain sensitive information pertaining to an individual, and not only the party, but children, parents, partners, spouses, businesses, etc., identities, finances, and health. Family law cases are rife with personal information. Court records can include drug tests with results, financial account information. A few years ago, I looked at an online docket and the attached documents in a family law case that was free and open to the public. It documented the sad decline of the family over the years of filings, financially, emotionally, and physically. A psychologist's medical notes, diagnosis, and invoice was attached to a motion for payment, which included the adolescent son's name, medical record number, date of birth, and his treatment for bedwetting. Imagine the consequences if classmates found that online. So, now that practical obscurity no longer provides implicit protection because of online availability, how are privacy interests being protected?
There are many authorities already that restrict access to some records. There have been legislation in the area of juvenile court records that restricts access to court records. There has been a public access policy for the magisterial district courts since 2010. Also, individual courts around the Commonwealth have adopted varying policies to try to address this issue as we became aware of it. These include requiring redaction. I think Judge Turgeon is here. Dauphin County was actually early in requiring that attorneys redact social security numbers and other sensitive information from court records that are filed. We have a similar rule in Montgomery County that we modeled on yours. Attachment to a subpoena, there may be required redaction, and this would be maybe what something would look like if the redaction is required. Confidential information sheets are used in some jurisdictions to require that any specific information be segregated on a confidential information sheet and filed that way, which then permits that the database, if there is a database, segregates that information and screens it from public view. Some records are sealed in some counties, and we have varying practices on that. Delaware County, all divorce records are sealed. In my county, Montgomery County, divorce matters are sealed with the exception that they can be accessed by an attorney. Some courts have adopted temporary online restrictions. In Allegheny County, a temporary order is in effect that says when jurors are considering a case, they can't access the records of the case online. In other words, we don't want jurors in the courthouse looking at the motion in limine that was filed the week before. when they're not supposed to have seen what was attached to the motion in limine. So there may be needs for temporary restrictions or limits. How do we approach this from a statewide point of view? One of our goals has been that geography shouldn't dictate what you can access and what you can't access and what's vulnerable and what's not vulnerable. We should have a uniform statewide policy, and the Supreme Court, in adopting this policy, is addressing that need. Why is it that some records are open and online and available and free in some counties, available but for a fee in other counties, available if you're an attorney in another county? And how do attorneys who have multi-county practices keep track of all these different rules and requirements, including redaction? So that's where we are today. It's a confluence of a number of factors, including e-filing systems and which have created electronic records, which we now have not uniformly across the Commonwealth, but in many counties across the Commonwealth, and the treatment of sensitive information varying across the districts. And now we have statewide e-filing at the appellate level. So for all of those reasons, we needed a much more uniform system that will apply, and uniform policy that applies to the appellate courts as well as all the trial courts. Litigants may be left in the dark as whether their private information and their intimate details in their divorce will be released online or kept private. One concern I should mention, particularly of abuse victims, in protection from abuse orders, there's federal statute that applies that says an abuse victim's address cannot be made public online. So when we have these online dockets, so we need to, this has been the law for now probably almost a decade, federal law, but we need to make sure that the online dockets have a way of protecting personal private information of that nature as well. And again, we wanted to make sure we gave uniform advice to all of the court governments and bar associations around the Commonwealth so that we're responsibly, the custodians are responsibly treating that information the way it's required to be treated under applicable law. So we proposed a policy. We had a working group that met beginning in 2014 and 15, maybe beginning 13. We proposed a policy and it was published for comment in 2015. We received comments from around the Commonwealth and from a variety of institutions and individuals, and the Supreme Court adopted the policy, as we said, on January 6th of 2017 with an effective date of this coming January 6th of 2018. David, are we up to you? The policy covers, as we said, appellate and trial records and how records will be accessible by the public, how requests for access are to be handled, applicable fees, and how parties and counsels must file documents that are sensitive or contain sensitive information. And let me just say, the focus for the Bar Association, I think, is what are your obligations? There is an obligation on every party and attorney filing documents to comply with the policy, to certify that you've complied with the policy, and to leave out confidential information that need not be in your documents, whether you use a confidential information form or redaction.
Just curious, I heard that whole list, and there was something missing from the list.
Okay.
In the confidentiality, has there been any discussion among the judiciary themselves as to what information should be included in the dispositive opinion? And one of the areas that I see this a lot is unemployment comp. I will recommend to people not to take an appeal. Once the Commonwealth Court decided that they were going to publish the unpublished opinions, then if your name's Yablonsky, you've done everything that you can to blackball yourself as a future employee. If your name's Smith, you're probably okay. But is the court looking at how much information do we need to put in an opinion to legitimately dispose of it? And how much of this traditional background preamble, he said, she said, might have privacy implications?
It's a great question. Let me say this, and Judge Cohen-Jubiler may want to jump in for the Commonwealth Court. Each of the courts will probably be making their own decisions about any policies they want to adopt consistent with the policy, but we are educating the judges and encouraging leave it out. If it doesn't need to be in there and it has a privacy implication, leave it out. We could probably have a discussion. I don't know how many family lawyers there are in the room, but the family law obviously very sensitive. I had a discussion with my bench one of the judges said, well, you need to put a social security number in a quadro every time. I said, no, you don't. Right? Federal law doesn't require the social security number. Maybe the last 4 digits, I don't think that's even required under federal law. The employer or the party that is managing the benefits may ask for it. I understand people do it a lot, but we really want to encourage the court as well as the filing parties to leave it out, unless it's absolutely necessary. And then if it is necessary, depending on your county, you're either going to be using a confidential information form for specified information, or you may be filing a redacted and unredacted version of the same document. But yeah, the first line of defense is leave it out if you can.
And thank you. I'm very sensitive to that. Actually, I forget how many years ago, maybe by now 5 years ago, I got a request from someone to take an opinion that was an unreported opinion off of the website and actually remove it, because the claimant was concerned that the denial of benefits and the discussion in the opinion was preventing him from being able to get another job. And when you talk about access to the courts, you want people to be able to use the courts and to have an appeal, to be able to come in and make their case and not be, precluded from that by fear of their personal information becoming public. On the other hand, there is a right to the public to be able to see what's going on in the courthouse and how judges are making decisions, to monitor for so very many different reasons, and we all can understand that. So it's a struggle, and so how many facts need to be placed in? And I think that's something we need to be talking about. I try not to use individuals' names in opinions. I mean, obviously, the parties themselves end up with their names in the caption, unless for some reason they're, initial or sealed. But anybody who's tangentially related gets a, salesperson or coworker or minor child, if I can do that to protect them. But we will have to be thinking about that. Thank you very much.
All right, yeah, thanks for being the first one to jump in the pool. This is an open session. This is an opportunity to ask us questions. This is just not a one-way street.
You get Bob over there.
So if you want to ask questions, well, except for Bob.
I feel the same way about Bob. But isn't there a danger, Judge, and particularly at the appellate level, that the more you sanitize the opinion, the less precedential value it's going to have, and that does a disservice to the rest of the bar?
You're absolutely right, and that's that juggle. In many of our unemployment comp cases, they're unreported. So there's any precedential value, they can still be cited for persuasive value. And you're right, the fewer facts you have, the less likely they are to be able to be used even persuasively. Good point.
Judge, couldn't you do it like we do in custody cases, use initials instead of names? And then you could have all the details of the case without losing the precedential value of your wise decisions.
And that's something to think about with regard to, I know that there have been, and I think recently, there's been some discussion in the family law area of how difficult it can be even using initials with case names and children's names, and trying to remember which LK versus CK that opinion was. Makes it hard to cite. And there may also be some legitimate reasons why people want to know who the people are in the cases. And when you're examining them for so many different reasons and trying to determine, whether, that justice is being fairly and impartially provided without regard to who an individual is and who the party is and who the judge is and what relationships or anything else. Not knowing who people are can interfere with that. And anyway,
Yeah.
On the transparency, I wanted
Yeah,
to clarify what I had done. I did a term of 4.5 years writing with the Superior Court, so I have a very practical view of it. And what I was getting at, particularly in employment comp, you've got an appeal where there were 8 allegations against the guy or the woman, and the decision is based on one of them. But the pattern for writing an opinion has always been the appellant raises 7 issues. Here are the 7 issues. If the disposition is based on one issue, then all of the facts relating to the issues that were not dispositive can be highly pejorative, can be pejorative not just to the person who took the appeal, but as you said, to the salesperson, to the other people, and it can literally destroy people's lives. In the process, all I was suggesting was in the process of this attorney consciousness of privacy, the other half is, transparency is really important, and knowing that there is equal justice under the law, really important. But there are plenty of salient, of salacious details that find their way into opinions, and I always scratch my head because it's a suppression order, and these were the facts upon which the suppression order was affirmed, and yet I've got all these other facts that weren't necessary to the disposition of the case, and they may have been raised by somebody, but do we really need to put them in a public record? And that was
policy. So let's just jump right into the policy part. So the policy is going to tell us how records are accessed. The policy is going to tell us about fees, how you actually make the request, what type of records are accessible, and it's going to talk about confidentiality and how we are going to treat them. There is sort of a background here. This is not a policy that was developed in a vacuum. The court over the last decade has implemented 3 other policies. First in 2007 with electronic case record policy. If any of you have ever used the web docket sheets and the AOPC website, and last year there was 60 million some people who accessed them, that's the policy that tells us what information is online. There's the 509, the financial records policy that went into effect in 2007 and already referred to the MDJ public access policy, which deals with access to the DJ records. So as you can see, we're taking steps upon building on the policies. So this policy in general is going to apply to all documents filed in any case. It does not apply to Register of Wills, so we can forget about them for a minute, on or after the effective date of this policy. So once again, D-Day is January 6th, 2018. So the good news is whatever we say today, you can go home today and it doesn't matter to you. It doesn't matter to you tomorrow. December 6th, it'll be very important, or January 6th, it'll be very important to you. So if you look at the policy online, and if you haven't, you should. Go to the AOPC website, Unified Judicial System website, click on the public records, you'll come to the policy itself. It's only 21 pages, it's not that long, but if you can only read 4 sections of the policy, read sections 7 through 10. Whenever you think of a public access policy, the question is, what information is being safeguarded? Sections 7 through 10 will tell you what information is being safeguarded and how it'll be safeguarded. Look at it as sort of 4 buckets. We have section 7, which is going to deal with just pieces of information. So like a social security number needs to be given to a court. Section 7 is going to tell us how we protect that one piece of information. Section 8 is going to talk about documents. There are some documents that must be given to a court that are so littered with information, you really must protect the whole document, like a tax return, like a medical record. If you look at that document and try to just protect the information on the document, you're going to end up having to remove from the public so much information from that document, it's going to look like something from a History Channel show where somebody sent in a FOIL request to the Department of Defense and they got back a document that was all redacted except for the date. So these are documents that the whole document must be protected. Section 9 is going to tell us what the public can see when they get to the courthouse. Section 10 is going to tell us what the public can see online, our practical obscurity section. So those are the heart and soul of the policy. So let's jump right into Section 7. These are pieces of information that must be given to the court, and how are we going to protect that? The default in the rule is a confidential information form. I think Dauphin County's already used confidential information sheets for a number of years for some cases. So if you're not familiar with them, it's the idea that I've got a pleading and I got a confidential information sheet, and I'm going to put the confidential information just on the cover sheet. I won't put it on the pleading. I will give both documents to the filing office. So a member of the public comes in, they can see the pleading, but they can't see the confidential document sheet. That's how this works. It's done at the MDJ level, been done for 7 years, done in some counties, as we've talked about here already. We've also stole it from some states, Arizona, Minnesota, and Washington. Yes, when somebody's already been the pathfinder, we're more than welcome to just walk behind them and smile. So, what are the pieces of information that we're talking about? There's not a lot, and there are going to be no surprises here. Social Security numbers, financial account numbers, except if the account number needs to be in the pleading and it's an active account. There are some provisions where you can just use the last 4 digits of the number, just the last 4 digits. Driver's license numbers, SID numbers. If you don't do criminal law, SID numbers are a specific number given to your fingerprints. So when you're fingerprinted, that is sort of the Social Security number for your fingerprints. So the next time I'm arrested, if I decide to give a different name, when they fingerprint me, my fingerprints are still going to go back to the number that's still going to show who I am. Minors' names and dates of birth, except when a minor is charged as a criminal defendant, and abuse victim information in family court actions. That is the list. So, we talked about AOPC, we're going to talk about AOPC is designing a confidential information sheet. It'll be similar to what counties are already using, who use them. We'll have that for you soon. Now, there is a decision here for the judicial district to make. They can choose a different path. If they don't want to use confidential information sheets, they can use redacted, unredacted copies. So what does that mean? A judicial district could say that whenever you file a document with the court, file 2 copies of it. File a unredacted version, which is everything in a document. File a redacted version that doesn't have the Social Security number, doesn't have the financial account number. Both would be filed, and then when somebody comes to the courthouse, obviously the public would only see the redacted version. Now there's pluses and minuses with each direction, whether you take left or right. Both of them are perfectly good directions to take, but each judicial district has the discretion to choose which direction to take. Dauphin County has submitted a local rule setting forth what their proposal is, so we'll see how that goes, but just keeping that in mind. Now, this section does not apply to cases that are already sealed pursuant to existing legal authority. So, adoption cases, juvenile cases. These are cases where the public can't see the records now anyway. So there's no need to take any additional burdens to safeguard things. So if you're in a juvenile delinquency case, a juvenile dependency case, Section 7 doesn't matter to you. You don't have to follow it. Okay, parties and attorneys. Parties and attorneys are solely responsible for following the policy. And they're going to sign a certification certifying that the filing, that pro se party, that attorney is filing, that the filing does comply with the policy. For any of you who are PACER users on the federal system, you know when you get to that point, you're getting ready to do the document and it's got a little checkbox there that you have to check and you can't go forward unless you check it. That says, I didn't put in, I complied with all, Rule 5.2 or something like that. That says don't put in the socials, don't put in the other. You got to check it. Same idea here. You're gonna do the certification. Court and custodians are not required to double check. Whatever is filed is filed. Now, some court or custodians may want to review things. That certainly is fine if a court or custodian wants to take on that burden. But under the policy, the only person who's on the hook is the filer. That's important. Parties' failure to comply with the policy, number one, doesn't make the document inaccessible. So, I'll be right with you. Let me just get out the thought, because I'll lose it. So, if you file a tax return or if you file a document with a social security number on it, when you should have put it on the confidential information form, that means when a member of the public comes to see that document, they see the social security number. Then, let me just take the question. Go ahead.
You're talking about filing these things, so
Mhm.
that tells me, as an old appellate lawyer, that it's in the record. What happens when the record, because now you have the complaint that doesn't have the confidential information in it, and the confidential information sheet that does. And for some bizarre reason, I don't know what it is, but the stuff on the confidential information sheet is critical to the appeal because the judge really screwed this up. So when it goes up on appeal, do both pieces go up?
Yes.
So they're in the record, they're just not available.
Correct.
Thank you.
Yes.
Right. And confidential information mostly are in exhibits.
Sure.
And
But the exhibits can be critical to the appeal.
right. And so while we're not the gatekeepers, when you're dealing with certain types of cases where 90% of the people are self-represented litigants, it becomes an ethical, moral issue as to whether or not you should be the gatekeeper to help these people protect themselves, and that's going to be a big issue.
Yeah, which is clearly a county's decision. If a judicial district wants their prothonotary's office, wants their clerk of court's office to review these, to review filings coming in or other people to review them, that's perfectly fine. But the policy places no burden for review.
Judge Turgeon, and I should mention that the AOPC is working, some filing officers are on our implementation committee. We have the clerk and clerk of work and support and prothonotory. And so we're working on handouts that the filing offices can give to pro se litigants when they come in to make them aware of what the requirements are. We're going to be doing videos, instructional videos that we put on our website. We're really trying to get the word out. We know what a challenge that's going to be for the courts and the filing offices.
Well, exhibits don't go to the filing offices. Exhibits are in the domestic relations office, they're in the custody conciliation office, they're in the courtrooms, all kinds of family law cases. The prothonotory doesn't review transcripts with exhibits. I mean, I'm talking about whole other.
Yeah. And our understanding is that the court reporting committee that promulgated the new rules of judicial administration on court reporting and transcripts is looking at the policy with possible amendments to what court reporters can put in the transcripts and not put in the transcripts.
Let's go to this gentleman here first.
Okay, and I have one question about building off of what Judge Turgeon said. If you're dealing with, excuse me, an administrative appeal from a state agency, and when you're putting together the agency record, for example, in my agency, if we were putting together an administrative appeal regarding the provisions of a domestic relations order that had a redacted or a domestic relations order that didn't have social security numbers and addresses and all that, and the confidential information sheet with all that information that was filed with the agency along with the order, when that agency record goes up to Commonwealth Court, what do we do with that confidential information sheet and things like that?
Well, I can say, first of all, that under the policy, original records and reproduced records are not going to be available online. So that at least helps keep the practical obscurity that's currently there.
And then, if a confidential information form is in the record below, it'll be part of the record at the appellate court, but it will be a non-public part of the record at the appellate court,
Okay.
just as it is at the trial court.
So they
As
won't
well
be,
the confidential documents.
right.
that
So they
may be-
won't be getting the reproduced record or the certified record with all of that stuff in there. That's not going to be readily available.
Correct.
Okay.
And I think
Just two aspects. One, just a suggestion, only as a former clerk. If we've got these confidential records below, and we're putting together reproduced records, it's probably going to be prudent to say volume 2 of your reproduced record contains confidential, and that however you bind your records, you bind anything that was confidential below separately from what is public. And that will help make sure that all of the clerks and all of the judges are well aware that that fact, whatever it is, was part of the confidential record. Second thing, and the question, I think it was Judge Turchin's comment about, yeah, there's a moral, ethical duty, and that's certainly true, but I'll bet my bankroll that the reason why there isn't a duty on the part of the court, and there is a duty on the part of the litigator, is the court has decided that when somebody sues over a screw-up, they should be suing the attorney and not the court. Because if the court imposes upon itself that obligation and the court fails to acquit itself of that obligation, you're going to be looking at lawsuits. So the court's voluntary actions that are not mandatory won't result in liability, but a mandatory obligation would open floodgates to litigation. Call me cynical, but that seems like a probable justification.
it's your guess, and you're allowed to have it.
I'm sorry, I could give you an alternate explanation that we really did discuss in our committee was the parties and their attorneys presumably know what's in the document. The clerk's office, many clerk's offices around the Commonwealth do not have the staff to read every document and don't know, and so they would be looking for things to protect where they don't know if it's going to be there or not. So the burden, so that's the real theory, at least from my point of view, is you should know, if you can make yourself aware of the policy, you should know what's in your document and whether there's an obligation to redact or, and so on. And again, my philosophy about this is if you don't need that information, leave it out. I mean, obviously, people like to put in lots of argument and lots of facts that may or may not be relevant, but if you know it's not relevant and you know it's compromising your client's private interests, leave it out.
All right, so we're going to chug right along then. So, it's the party's responsibility. This is important. The policy permits sanctions. The court may sua sponte or upon motion of a party, if a filing fails to comply with the policy, the court may impose sanctions. The policy does not define sanctions. It does not get into the realm of details with that. However, there have been some other federal courts who have dived into the pool. So we're going to take a step to Minnesota. Once again, so this is federal courts. Remember, in federal courts, you're not supposed to provide the entire Social Security number when you file something. This attorney provided 179 of them. But don't worry, he explained to the court that it was his administrative staff's failure, not his own. The court was not very sympathetic. Counsel was required to notify all the individuals whose Social Security numbers was released about that, and was required to pay $5,000 to a local food bank. Next individual is a Triple Crown winner. As you may know, in the federal courts, you don't provide full dates of birth, you don't provide names of minors, you don't provide full account numbers, and you don't provide full Social Security numbers in violation of 5.2. This person ran the table. He did them all. This person was required to notify each individual whose Social Security number was released, or required to notify everybody whose information was released about that. If your Social Security number was released, the attorney was required to acquire credit monitoring services for you and then pay a $300 fine. So obviously we don't know what will happen in Pennsylvania, but that's what we've seen in other places. Now we're going to move to bucket number 2, section 8. These are documents. So these are documents that have so much confidential information in it, the only way to truly protect them is the document is not going to be accessible to the public. Once again, these are not going to be surprises to anybody. Financial source documents, tax returns, W-2, wage stubs, earnings statements, credit card statements, etc. Obviously, if you notice the slides when Judge Renee Cohn-Jubileer was up here talking, she showed the case where they gave out the full American Express account number. And the same case where they gave out the defendant's social security number, has dates of birth, financial account or address. I mean, what more do I need to do to steal the person's ID? People in China are breaking in the systems. You could just go to this county system and do it yourself. Second records, medical and psychological records, children, youth, and services records, minors education records, and then the last three are documents for family law cases, marital property inventory and pretrial statements, income and expense statements, and agreements between the parties. So as you can see, the list is not very long. Now, once again, just like with Section 7, if this is the case where the information's already sealed or already accessible, the type of case, juvenile, adoption, this does not apply to you. We're not worried about protecting these in a dependency matter or an adoption matter or similar matters. But once again, responsibility is upon the filer. The filer is going to file the certification just like in Section 7, and same rules apply here. Court or custodian is not required to check. Responsibility is only on the filer. Sanctions can come into place, and we just know we borrowed the idea from a couple of states like Minnesota and South Dakota. Now with Section 7 and 8, we're going to have confidential information forms. We're going to have confidential document forms. So just in case I went too quickly and didn't say this, with a confidential document form, so I want to give a tax return to the court. I print out the confidential document form. I list that this is David Price's tax return. I give both documents to the filing office. Now, if a member of the public comes, it's a little bit different than the confidential information sheet. If a member of the public comes, I can see the cover sheet that says this is David Price's tax return. So there's some transparency there, so the member of the public knows that the court has the tax return or the medical record or whatever, but they don't get to see the record below. The actual form itself remains confidential. So AOPC will be designing these forms as well as the certification form. Our hope is you're going to start seeing some sample forms in September. We're really close. Yes, ma'am.
What about the crossover document where, for example, a police report is arguably a public document, but it has information about minors involved in a motor vehicle accident? And are we to take it upon ourselves, per this policy, to make those redactions even though the information could be found publicly elsewhere?
So, just so I'm understanding the question, so you are attaching a police report to something you're going to file?
Correct.
And the police report has information under Section 7 that's not accessible?
Correct, but would otherwise be considered a public document under a different set of public record standards.
Yeah. So if you are filing an exhibit that has, say, a minor's name in it, you are going to have to redact that exhibit. And I think Andre already said this before. As one of our big pushes, we're going to have posters, we're going to have handouts, we're going to have lots of information, videos, etc. Yes, sir.
In cases where you have like a business dispute and you have a protective order at the trial court level, and things are exchanged in discovery that are not confidential, does Section 8 cover those kinds of documents at the trial and appellate level, or is do they fall into some other section?
So if it's already sealed pursuant or protected pursuant to an order, then you're not really worried about Section 7 or 8. The only thing I would say is, if that document ever comes out of the protection, then you've got to look at 7 or 8. But if there's already a court order protecting that document, protecting that case, I think you're fine.
Okay, because I think trial courts are generally equipped to file things under seal, but we've had experiences in appellate scenarios where it has not translated well into an appeal, especially if the case was, for example, dismissed before trial. There was no public trial or hearing. Nothing came out. Some of the stuff is still confidential. So could we have a scenario where we don't need to worry about this policy at the trial court, but we might have to invoke the policy in the appeal?
Well, actually, there is, and I believe, I don't believe I'm talking out of school, but I believe just within the last couple of weeks, the Appellate Rules Committee has published some proposals, some dealing with public access. I believe the one that deals with public access deals specifically with your issue in saying that they're changing the rule, I forget which rule it is, to say that if a document is sealed at the lower court, that when it comes up to the appellate court, it remains sealed unless the appellate court orders otherwise. Because I think in the past there's been confusion that when the case comes up, okay, common pleas Judge A sealed it.
Right.
But it's now up here, does his order come up?
Right.
But I would take a look at the Appellate Rules Committee proposal, because I think it's right on point to what you're suggesting. Yes, let me go to her first, just to the change.
I still have a question about exhibits. Because
Okay.
the exhibits aren't filed by the parties necessarily. They're introduced at hearing, and then they're either being filed with the transcript by the court reporter or, you know, in some other instance. So what...
You mean like
what
an
do we
exhibit
do?
coming out in a
I'm a
hearing?
divorce master, so when I write my report and recommendation, I file my report and recommendation, and at that point, I file the exhibits with the pathonetary. Now, up until now, we've been redacting personal information, but tax returns have been filed. We've just been redacting all of the social security numbers, dates of birth, children's names, you know, that kind of information. But now, under this policy, when I file a tax return, do I pull out the confidential records from the exhibits and attach some kind of sheet, or do I ask the pathonetary to put it under seal? Or because it's not the attorney. I mean, certainly the attorney should be giving it to me with the information redacted, but it's not the attorney filing it at the pathonetary's office.
Yeah,
It's
and
me, or the court, or the
well, if the court,
reporter.
this is for party file the documents. If the court is filing something, this does not apply to the court.
But as a best practice,
Yeah.
query whether you're a party or you're not a party, the court has appointed you. The practice, I think, the best practice would be you do your report, you make sure you exclude as much information that would otherwise be confidential as you can omit. If your report is going to have information that should be redacted, you may need a confidential information form with your report. And as to your exhibits, you're going to want to, if you have exhibits A through G, and F and G are tax returns, then you attach A through E, or whatever F, you know, and A through E, and then F and G, you would put a confidential document form with your tax return saying these are exhibits F and G, but I'm filing them separately under a confidential document form, so that they'll be maintained in the record as a confidential document, but there is transparency that you filed them. Does that make sense?
Yes, sir.
Just clarification. One, on the confidentiality agreements, all of those agreements, only 90% of them say until you sit trial. And then at trial, the judge decides whether it's part of the record or not. But in the divorce master's case, I actually think that's something that a specific rule needs to be adopted, or a clarification of the rule with regard to proceedings in which exhibits are presented in the proceeding, which will later be included in court records. I think the attorney who is authoring that document in the hearing has an obligation to mark it with a cover sheet, so that it is not the divorce master's responsibility, it's not the divorce judge's